Business Hour with Ollie Bocheng on OFM.
Welcome back to the OFM Business Hour. Now, as the countdown continues to LabourNet's Complementary Compliance Workshop on the 17th of March, we're unpacking the different pillars of labour compliance, navigating health and safety, skills development, and labour law. We know that can be quite complex, but with the right guidance, it becomes far more manageable. And speaking of that guidance, we're focusing on labour law compliance with the team from LabourNet. We're joined by Stephne Louwrens. She's the labour law manager at LabourNet. How are you, Stephne?
Hi, Ollie Bocheng. I'm good, and how are you?
Why do so many employers find labour law compliance challenging in day-to-day operations?
So, Ollie Bocheng, I would say over the past years, there's been significant changes in Labour Relations Acts, in our labour legislation. There's been significant increases in labour-related disputes, many of which could have been avoided if obviously there's been clear guidance on compliance. So businesses often genuinely wants to do the right thing, but South African labour legislation can feel overwhelming, it's complex, it's highly technical. So employers know what outcome they need, but the law prescribes specific procedures on how to get there. So whether it's misconduct, poor work performance, incapacity, or even restructuring, some scenarios require a different statutory process. So missing even a single step in that process might lead to adverse findings at the CCMA. So compounding this challenge in the constant evolution of the labour legislation, employers are expected to keep up with this ongoing developments and amendments and regulatory changes and updates. A current example is the Labour Relations and Labour Law Amendment Bill, which was published for public comment now in Feb. And this bill proposes a wide change of multiple laws, including our Labour Relations Act, BCA, Employment Equity Act, and these shifts require employers to constantly update their policies, contracts, their practices to remain compliant. So for many organisations, especially those without internal labour law experts, this creates an ongoing operational pressure. Many companies simply do not have the training or resources to manage all these moving parts.
Thank you for that, Stephanie. What risks do employers face when labour law procedures aren't followed correctly? What would you say are the biggest challenges that you see?
So I think the biggest risk would be ultimately to end up at the CCMA and lose a case. So whether this is for procedural or substantive unfairness, even when employers have a good reason to act, they can still be penalised if correct processes aren't followed. Or if they follow the correct processes, they might be penalised because there's not a good enough reason to have acted in the first place. So I would say definitely the biggest challenge is understanding what fairness means in the context of taking disciplinary actions or dismissals. I feel that employers often struggle to find that balance between substantive and procedural fairness to determine when can they act and what steps do they need to take. So it might be well intended, but it might be found to be unfair at the CCMA.
Sure, we're joined by Stephne Louwrens. She's the labour law manager at LabourNet, overseeing the Free State and the Northern Cape. That's much of our region, by the way, if you're listening in from the varied provinces. Stephanie, can you break down what qualifies as a fair reason for dismissal? I'm sure all the employers' ears will go up at that question.
Absolutely. So basically, the labour law recognises three categories that you can fairly dismiss someone on. So the first one would be conduct, and that basically relates to behaviour, rule breaking, if there's policies in place and employees don't follow the rules of the company. Then you get the second one, which is capacity. So this is normally where an employee wants to perform their duties, but they can't due to a lack of either knowledge or skills or experience. And then as part of that, you also get your ill health, and we all group that under capacity. And then lastly, you get your operational requirements. So this is where operational needs of the company change or shifts, and based on that, they need to restructure or some positions become redundant. But I think what matters most, regardless of one of the three that you dismiss someone on, is that you correctly identify which category this dismissal will fall in, and then ultimately follow the process that then is regulated by that part of the category that you're going to use.
All right then. Well, how can employers better mitigate risk before taking disciplinary or dismissal action?
So I think here would be that the best approach, and we've seen this over and over again, is a proactive approach. So making sure that you have policies in place, that you document all your incidents, that if there's breaches of rules, that you actually issue warnings when necessary. So I think training your managers also on what is expected of them and what the Code of Dismissal recommends, what your company disciplinary code recommends, so that they know how to go about this. And lastly, I think addressing these problems early enough so that it doesn't escalate, and when you get to a point where you want to dismiss someone and you haven't followed all these processes, you're going to have problems at the CCMA. So I think just being proactive, keeping records, you would be in a much stronger position when you get to the CCMA.
Well, I mean, our discussion with Stephne is a part of a series with the team at LabourNet, and that's because they're hosting a workshop soon in which some of these different focus areas will be addressed at length in great detail. Tell us, what can attendees expect, and most importantly, how can they book?
The workshop is called Labour Law Compliance Made Easy. It's designed to give employers practical tools to confidently handle dismissals, how to apply the Code of Good Practice, how to reduce the risk that you face in workplace disputes, and then ultimately what would be a fair reason to dismiss someone on. So how do you go about the procedure? What do you need to look at in terms of substantive fairness, and how to take action when exposing your business to these risks and how to go about it. So the workshop takes place on the 17th of March at 9 o'clock, and you can just send an email to Pieter at pjordan@labournet.com, and he will send you the RSVP link. And yes, I think that's it. We're looking forward to helping organizations strengthen their labour law compliance.
The Business Hour with Oli Bogeng on OFM. The sound of your life.